Welcome to another session of this conference, the Global Law School Summit. The panel for today that we will be having right now is called Law and Other Things, Widening the Disciplinary Scope of Law. And we have an excellent panel, quite a unique panel in many ways, that will be helping us think through this particular topic. What is remarkable about this panel are two things. One is that all our scholars who are set to speak for our panel, who are on our panel, are from the global south. A very rare occasion that we have two scholars from Africa and two from Asia, and a couple and one from Latin America as well, who will be there. And all of the speakers who are supposed to be on our panel have been dean of a law school, or are currently dean, or have been in the past. So that leads us to interesting possibilities in our conversation today. So the theme, like I said, is interdisciplinarity, and that has been a kind of a buzzword in legal academia for a long time now. It has risen rapidly as a trend in the last few decades in various aspects of legal education in India, which is where I'm located. This has led to an overhaul of the legal curriculum in the last 3.5 decades, with the introduction of the 5-year program starting in 1987, which made it mandatory to study non-law subjects as part of the law school, and that has become the norm at some level all over the country now. So this has led to interesting challenges to legal education, and both legal research and pedagogy has had to adapt to these changes. And simultaneously, there's been a massive kind of a renaissance in scholarship around law in social sciences and humanities as well, besides, of course, in the law schools. So, while obviously there has been a kind of a interdisciplinary revolution of sorts, which has been going on in the field of legal education in the last 25, 30 years, it would be interesting to reflect on whether it has actually permeated the realm of professional legal education itself, which is in most of the world continues to be the main thrust of legal academia. So it would be interesting to reflect on how and if interdisciplinary has been able to find a place in professional legal education, or even to think about whether there should be a need to distinguish between professional legal education and academic legal education, whether they have to be taught differently. In any case, these are all interesting questions which our distinguished panel for today will help us discuss. And I'll just introduce them briefly. I'll just be brief with introduction. They're all distinguished scholars, but the first person who I would introduce is Professor Dr. Amita Dhanda, who is currently a Professor Emerita at the Nalsar University of Law in Hyderabad. She's a very well-known scholar who is, generations of law students have learned from her directly and indirectly from her scholarship as well as her pedagogy. So we're excited to have her. We also have Professor Hartini Saripan, who's the Dean of Faculty of Law at the Universiti Teknologi in Malaysia. So these are the two Asian scholars we have. Then we have Professor Lynn who's currently the acting executive director at the Nelson Mandela School of Law in the city formerly known as Port Elizabeth in South Africa. I am not familiar. I couldn't catch on the new name. So Professor Biggs is also here, and there are two other scholars who are supposed to join us. I will just introduce them when and if they're able to join. They may not be able to join because of time issues, etc. So let's start without any further ado, because we have limited time. We have just an hour to discuss this issue. So I will start with a kind of an open-ended question with regard to: do you think, firstly, there has been a rise of interdisciplinarity in legal education, and particularly in your specific journeys as a law student, as a law professor, as a legal academic, and as deans in your respective places? Do you see that a kind of a rise in interdisciplinarity in the field of law in general? So we can start with whoever wants to speak first. I think Professor Dhanda, you're muted if you, sorry.
Yeah. No, I was just saying, I think that the moderator will have to work that one out. We are not raising hands.
Oh, sorry. No, that's fine. That's fine. That's perfectly fine. And so please,
I suppose maybe alphabetically, I do work out as the name-wise I am an Amita, so I can begin.
Yes, please do.
So I would say, Anuj, it will depend upon you're asking the question for where. Like in India, interdisciplinarity is definitely on the rise when it comes to the national law schools. Basically because of these being 5-year programs, your social science courses and your law courses are, are meant to run together. Different schools have worked it out in various ways that you have maybe the first 2 years, you spend much more on social science and humanities, and the next 3 years then it becomes like a pre-law, post-law kind of thing. But progressively, at least I can say for Nalsar, and I think it's happened other places too, that you've started running them like parallel tracks, so it's not like you study your social science courses in the first 2 years and then you don't visit them again. We have, like, at least in our school, you can't get your degree if over and above the mandatory social science courses, you do at least 9 credits worth of seminar courses in social sciences. Also, kind of with the course, we have had, brought in a whole range of visiting electives, getting people from all disciplines to come and teach. So consequently, you've enhanced the engagement of legal education with other disciplines and what they have to say on issues which concern the law, but which don't only concern the law. So one is stressing on the fact that this doesn't only concern the law. So if I was to make it as a statement, I would say that yes, in these law schools, it has increased. I don't think in traditional legal education that much of a dramatic change has happened.
With the bigs.
Okay, well, the situation in South Africa, hello to the other panelists. The situation in South Africa has also had quite a historical development because of the history of South Africa itself. And in the early 2000s, the Bachelor of Laws degree was and legal education was actually under a lot of scrutiny and criticism from the profession. So there was a complete overhaul of the Bachelor of Laws degree, and what happened is that the various law deans from various the public universities got together and drafted a qualification standard for the law degree. And that was introduced in 2015, and then soon after, in 2016, there was a national review of all the law schools and of all the law degrees that were offered and legal education offered across the country, and of course we all had to apply for reaccreditation. In terms of the reaccreditation criteria from our Council of Higher Education, as well as our qualifications authority, and in line with the standard. And this qualification standard clearly it required that the law degrees, we also have 2 different versions. We have a 3-year, whether it is a social sciences or even a humanities type of degree, followed by a 2-year degree and a combination. But that is more in the minority of the type of degrees, law degrees that are offered across the universities. The bulk of the degree or students that do it, we have a 4-year law degree. And the 4-year law degree is obviously more popular because of the funding issues related to a 5-year degree. But be that as it may, the standard required that the other disciplines other than law had to be incorporated into the law degree because in order to provide the additional scope and to introduce these students to different disciplines other than just law. And then from the national review, it became quite evident that, you know, law that was the way it was taught and the way in which the various institutions were approaching the legal education was almost very much like in you know, only law, and the students needed their horizons to be broadened and introduced to other disciplines. So there's a twofold approach. There's the combination of a law and another degree kind of approach, and then there's the 4-year degree that where we are required to introduce more disciplines into the degree itself.
Thank you. Professor Saripan, do you want to reflect on this as well?
Yeah, thank you so much, Professor Anuj. Hello, Professor Biggs, Professor Dhanda. Greetings from Malaysia. Well, in Malaysia, I think I agree with the rest of the two panelists that we are witnessing the transformation of the direction of the legal profession. And I think I am very, very excited to also mention here that part of the factors or the main factors of this transformation is the fact that we are moving from what we call content-based to skill-based as far as the legal education is concerned. In fact, it is not just for legal education. We are speaking about the vision of the Ministry of Higher Education in Malaysia. So the content-based curriculum has very much influence on the tools and the techniques that the law schools choose in order to deliver our curriculum. As far as the legal profession is concerned, it is very interesting to note that in Malaysia, we are quite traditional in the sense that the professional body only recognizes the 4-year program of our LLB, that is the bachelor degree in law, and the integration of law and other disciplines are not recognized to practice in Malaysia. So as much as the rise of interdisciplinarity in Malaysia, I think, you know, it is safe to say that we embrace and we acknowledge the importance of social sciences, you know, into our field or into legal education. But what we are emphasizing is basically how to use social science technique as our tool and technique in terms of teaching pedagogy to deliver our legal content more effectively. It's just, I think, you know, there's a famous saying says, we are playing in the new, playing old game in the new playground. So I think that is what we are doing in Malaysia in terms of the legal content and the emphasis of the doctrinal, or what we call black and letter technique, you know, of delivering our legal education. It's very much, you know, traditional in a sense that we are focusing on the understanding of rules and laws. But more importantly, I am saying that how the law school in Malaysia incorporate social sciences techniques and skills into our curriculum. And we may not translate it into a program, as I think all law schools in Malaysia, in terms of the law program, since our professional body only recognizes our LLB. So in terms of the program, we only have one program that is a Bachelor of Law Honors. So law and other fields are actually basically not to say that they are not important. They are important, but graduates cannot actually practice. So law school, in the public law school, we are focusing on our LLB program, but taking into account how we want to incorporate other skills, referring to a variety of models that we have in order to produce high quality law graduates. You know, we have Delta model, M model, you know, we have so many models producing good or high quality law graduates. We are incorporating all that because we embrace the fact that mastering the basic legal knowledge per se is not enough for our graduates to shine in the industry. So the feedback that we receive from our partners, particularly our industry partners, they want more. They want more than just criminal procedure. They want more than just civil procedure. They want more than just traditional legal knowledge or legal body of knowledge. So these skills, you know, I can name few. We talk about entrepreneurial skill. We talk about definitely communication skills, and all these, you know, require deep understanding and a mastery of other fields. And I think incorporating some techniques that we borrow from other fields would definitely benefit us in the legal education.
Thank you. Maybe we could reflect also on, do you see this changes as an unqualified good? Do you see any dangers with this kind of rise of interdisciplinarity, or do you see it as overall a positive development? And it's because all of you obviously have had long careers as students, as practitioners, or as pedagogues, and now, you know, as institutional, as former or current deans. It would be interesting to hear your opinions on this question. So we start with you, Professor Dhanda.
Okay. See, if I was to process what my other two colleagues had to say, and especially what Hartini was speaking about just now, wherein whilst you are stressing on the fact of the need for studying and being aware of things other than the law, you're still saying that foundationally you stay with, you know, a kind of a strong legal base. And I think to some extent that's what Lynn was also saying, at least the way I comprehended the presentation. The way I was just reminded of one of the comments which Professor Upendra Bakshi tends to make in relation to students from the national law schools. They're saying they don't know the law. So it's like one of the things that he says that, you know, because they have gone peregrinating to other disciplines, they can give you a spiel on a number of things, and they have an opinion on everything, but they don't know law. So now one way of processing it, of course, is that is if you're going to operationalize law necessarily as a positivist enterprise, something which has its own, you know, like its own way of studying, which you need to be knowing. So one of the difficulties somewhere, Anuj, which I think we all need to be reflecting on, and I would somewhere, let's say, like much more in the recent past, I have started to appreciate the importance of positivism. To be saying that when you speak in terms of a rule of law regime, and when you say in very black letter terms, this is the law and this is not the law, are there situations and circumstances where you want that kind of definiteness, where you want that kind of, because there's this possibility of opening up the world and understanding the discipline of law in very many layers. And I definitely, for me, I've been like a committed interdisciplinarian through my entire career. And I don't think I'm abandoning that in any which way. And I also do think that bringing in that extra version or getting people to understand that the law doesn't just fall from the sky. There are a whole range of other interconnections that you need to make if you need to have a rounded understanding of the law. So that would be my pro-interdisciplinarity, proposition, let's say. And but unqualified good, that's the part that you asked. And for that, I'm saying I deliberately started the other way. One of the difficulties that you run in with sometimes, or maybe often, is that when you go the interdisciplinary route, you land up losing your way in your own discipline. And that's what I meant by not knowing the law. It's not like there isn't critique inside the law. And there's also the necessity of making those connections. What we basically want is that our students should have both. You have this kind of like a vice-like grip of the law, but you also have a contextual understanding of that law. That context gets created for you from other disciplines. But exactly how that knowledge that you get from the other disciplines, you need to navigate in the law. You need to have a pakka kind of knowledge of the law also. And I think that's wherein I would somewhere want to say, if I say it as unqualified good, then we don't ask so many questions on, okay, with how much depth do we teach the law? Do we only teach legislations, or do we also get students to look at rules, regulations, notifications? Do we look at the entire, there's the entire gamut of, though we say that what happens in Parliament or the entire extrinsic aids, how much attention should be given to them or not. But that entire legal process has a great bearing on how you understand the law. And if you don't have it, I know for a fact as a teacher of interpretation, that if you have that extrinsic aids ka knowledge, the manner in that will influence how you read a statute or how you read a judgment is extremely important. And I'm a little bit kind of wary on that count, that if we go too far, okay, let me make a different point, just make a little bit of a step back and say that along with interdisciplinarity, I think why it's extremely important to have a grounded legal knowledge is the whole area of intradisciplinarity. You can't be saying I'm only a right year specialist, that I only know constitutional, not even constitutional law, that actually constitutional law is one of those areas of law which you can't do any area of law without knowing constitutional law. It's as simple as that. But saying I'm only an IP person, or I'm only a corporate law person, and not seeing these interconnections between other areas of law to say, okay, and that's wherein, for why I would want interdisciplinarity is, if somebody comes and tells me I'm only a court law person, and you don't know that corporations are the new state, and you don't understand the interconnections between how corporate law operates and gender, or between corporate law and caste, then your understanding of corporate law itself is very superficial and hollow. On the other side, if I only know the gender and corporate law thing, and I know the caste and other things, but I don't really know my legal marbles, then I'm not going to be able to really use all of that, the point which Hartini was making, that the corporate law firms want people to have deeper knowledge and stuff. The reason is, if you want to make first principle arguments, if you want to be getting people to traverse new arenas, it's not going to come necessarily from only the law. That wider background knowledge or foundational knowledge comes in from other disciplines, and it's important to have it. So I'm in for like wanting these to be melded in some manner. So, and interdisciplinarity in a manner wherein law doesn't, or at least law people or law students or law teachers don't lose their grounding in their own discipline altogether. That is problematic. That is problematic. I don't know whether I've satisfactorily answered your question.
No, that was really very, very interesting. And I'm actually quite sympathetic to your point of view on this. Professor Biggs, you want to also reflect on this?
I think I could agree with Professor Dhanda in that regard as well, you know, in the sense that the whole reasoning behind the overall of the LLB qualification in South Africa was because of the very narrow approach that the students, the kind of knowledge that they came out of, you know, with graduating with was very law specific. And even within, as you say, with the interest perspective is within the qualification, the students tend to look at the various subjects or modules or in silos that they couldn't, you know, go from the basics of the law of contract and incorporate, you know, the other aspects of the law of contract, you know, like with regard to a specific contract in the corporate field, you know, so they would look at things in silos. So it was a twofold and manyfold actually approach to really look at each institution was given that ability to, well, what are we going to do to our qualification to make it relevant and current and adaptive and flexible, so that you can produce you know, knowledge for graduates that can be flexible in their careers, you know, so that and in order to do that, the students need to be exposed to more than just the law. And very interestingly, the preamble of the LLB qualification standard specifically, you know, I'm going to just read a little sentence here for you. It says, you know, it's necessary to have the appropriate legal education as the foundation to foster the ideals of transformative constitutionalism. Legal education as a public good should be responsive to the needs of the economy, the legal profession, and broader society. It must produce skilled graduates who are critical thinkers and enlightened citizens with a profound understanding of the impact of the Constitution on the development of the law and advancing the course of social justice in South Africa. Moreover, the law graduate must be equipped to discharge his or her social and professional duties ethically. And therefore, higher education must also be responsive to globalization and ever-evolving information technology. So it's a lot broader. You know, you want you want to expose and ensure that the content is a lot broader and give students a broad range of skills, so that it's not just necessarily strictly law bound, because we utilize the law and we turn to the law, and it's in a contextually based situation. So the students would need the ability to practically and you know, consider the law in that particular context, and to ensure that the education that they have is relevant, and that it's current. So it's you know, for that reason as well, that the qualification, as I indicated previously, to say that, you know, we have the basic discipline of the law, the fundamentals of the discipline of law need to be incorporated in the qualification. But together with that, some other aspects of other disciplines need also to be incorporated, so that the graduates do have the ability to problem solve, make use of the skills that they've acquired from the other disciplines as well, in the context in which they are then going to be utilizing the law to solve those particular problems. So you know, it gave us all the opportunity to really reflect on our qualification and take it through a process that we could look at it from all angles, and develop something where hopefully, because we've only just introduced our new qualification in 2020, the graduates are more well-rounded and have the skills and the competencies to adapt and transfer their skills and knowledge depending on the context, the environment, the whatever areas within which they are functioning. So yes, it is important, vitally important for the different disciplines to be incorporated. I do want to pose a question to you as the moderator, though, is the understanding of actually what interdisciplinarity actually means. Because I think we might all have a different interpretation of what it actually means and the context within which it operates. But I'm going to stop there and hand over to back to you.
Thank you, Professor Biggs. I would definitely like to react to Professor Biggs' question, but perhaps we should let Professor Saripan also reflect first, and then we will continue our conversation.
Thank you, Professor Anuj. Yeah, in fact, I am very thrilled to hear from Professor Dhanda and Professor Biggs, the fact that you emphasize on the importance of the foundation and the basics. And that is, I think, all of us agree today based on our responses that approaching law using social science techniques, for example, should not be diluting or annulling the specific legal contents or the fundamentals of law amongst our law students. And I think that is also the reason why we are still playing the old game in the new playground. The new playground is where we understand this generation. We know that there are more innovative tool of teaching delivery without compromising the fundamental of the old game, that is to produce high quality law graduates that definitely equipped with a very strong legal contents. And I think I would also like to add one more point here, that it is I think it is also relevant to include the understanding of how we actually bridge what is the law in the book and the law in action. Because bridging the law in the book and the law in action would, to me, would really reflect what it takes, to really produce law graduates that are able to translate what is the law in the book to the law in reality. Because, all of us, we know that when they actually go to the real battle outside after their graduation, there are things that they may not found during their law schools. And this is where law schools are important, to give them the right tools. And I think to relate back to our direction here in Malaysia, that skill-based rather than content-based, not to say that we dilute the legal content. Legal contents are there, but we embrace and acknowledge the fact that when we give them the right skills, and that is definitely start with the right foundation, the right substantive law and procedural law, and our accreditation body. I think, one of the main reasons for not recognizing programs that integrate law and other fields is because of this reason. They don't want to dilute the fundamental legal body in our program, and for that only LLB or what we call the 4-year law programs in Malaysia are recognized to practice. And I think, another point is, Professor Dhanda mentioned just now, when we expose too much to, other disciplines, there's a danger that our students might fail to see the real picture. They might be seeing the big picture, but eventually there's a danger of not seeing the real and the right picture, and eventually forget what is basically the core competencies that are required, for them to master during their years in the law school. So I think interdisciplinarity should enhance the legal skills, and that's why I always like that Delta model, where substantive law or the law part or the legal skill is a foundation forming the triangle, whereas other skills are actually at the sides of this. We are talking about interpersonal skills, that I think is very important. But the bottom line is that we need to again go back to the purpose of training our law graduates. That is to make sure their ability to bridge what is in the book and what is in action. I think I will stop there first, Professor Anuj. Yeah.
Thank you for this, Saripan. So yeah, this was very interesting. I think a good question was asked, because what do I mean by interdisciplinarity at all to begin with, right? That we didn't do the definition and move at all, and we just moved straight into like in media res, move straight to the. So yeah, I think perhaps the classic definition of this kind of question of counterposing the legal approach to the professional legal approach to study of law versus the kind of social scientific way of thinking of law, probably by Max Weber, sociologist Max Weber, writing about it 100 years back, where he talked about as a legal scholar, you're interested in the classic sense. Obviously, now it's become all very, things have changed a lot since then. But the kind of pure sense, the kind of ideal type, would be in the sense of, you're trying to figure the normative dimension of law, right? That the focus of a legal scholar, and a social scientific scholar would perhaps be more interested in the kind of the sociological element, in the sense of how it is intersecting with the world as it is, and the kind of. This is of course highly simplistic at some level, but just to kind of place it there. Now, what has happened is that over the last many decades, especially in this country, which I'm most familiar with, India, we've had institutional attempts to actually successful in the sense of institutionally being able to do an overhaul of attempts at professional legal education being significantly forced to have a significant chunk of social science courses as part of getting a degree in as a practicing lawyer. Now, while in some ways it's successful in the sense that, as Professor Dhanda said, it started with the national law schools. Now it's pretty much all over the place. It's almost difficult to find a good 3-year degree, and the old 3-year LLB degree, which used to be the norm, say 35 years back. It's become more and more difficult to find a decent, to the extent that, interestingly, the place we started the interdisciplinary approach, the so-called interdisciplinary approach, the National Law School Bangalore is actually now introducing a 3-year LLB, which will be interesting to see how they go about it. But I just wanted. I'm actually very sympathetic to the view that Professor Dhanda and Hartini also just mentioned. All that I see the challenge of interdisciplinarity also in terms of, I think of them as two different languages of thinking about law. And problem is that people think of it often as a kind of easy way out. Rather, it's really a much harder way to study law, to be able to do both. When you try to learn two languages as opposed to one, it's actually much tougher. But somehow the way, because of there's a kind of a too simplistic way of doing this kind of shortcut way of towards interdisciplinarity, which I personally have experienced in various capacities, which worries me about this turn actually at some level. Because often I feel like the students neither know law nor sociology or economics or political science or any of the social science. So that worries me, because I feel like, that's Professor Dhanda said, these students, including Professor Bakshi, that that they don't seem to know much law beyond a point. They're good at talking and they're good at being able to hold forth, but do they actually understand? And that's something I feel particularly, because there's kind of a normative world behind law also, right? So this, I'm obviously most familiar with India, and here there's a kind of wholesale experimentation with the legal system that's been going on for many years now in all kinds of ways, in which somehow very often depart from certain fundamentals, certain normative fundamentals of the legal system, the common law legal system that is prevalent here. somehow I don't see the legal either legal academia or legal professionals or the legal complex, broadly speaking, react in any kind of. I mean, they seem to be open to all kinds of experimentation, which is very interesting at some level, and perhaps that's where, I mean, this is a long discussion, and I think we should move on to. But I think this is partly connected to the question, the fact that all of South Africa, Malaysia, and India are all, of course, ex-colonies of ex-British colonies, and the British model of legal education is very specific. I mean, it's a very minimalist model at some level, right? It's, of course, you could do a 1 year degree and you can qualify with practical experience, and of course you parallelly had research-based legal education, which is also there, but that's for training legal academics largely. So the legacy of that, and how, as Hartini also mentioned in the context of Malaysia, how, and I think even in India, however we may claim of the triumph of interdisciplinarity, actually at some level the profession has very little patience beyond the point with all this. So I just thought, maybe we could reflect on the aspect of what you think, locating your respective country or the context you're most familiar with, the experience of interdisciplinarity in the context of the global phenomenon and global a la British or American kind of the global north. How do you locate that in the conversation of interdisciplinarity in your respective countries with that in the global north? Yes, Professor Dhanda.
I just wanted to, for a moment, Anuj, seek your indulgence and make a little bit of a response to what my colleagues had to say after me.
Yes, please, please.
And possibly that will also kind of, sort of flow into the question you're raising now. What I was saying basically was that in our foray or entering into the whole arena of interdisciplinarity, we somewhere kind of made this, I would say, a little bit of an error. Even in the all national law schools, you still have true-born traditional black letter law teachers who only teach that. And at the same time, you also have teachers who try to, like, say, place the law in context and teach it from there. You also have a third body of people who just teach the context and don't really then spend as much time comprehending that there is an entire, let's say, an entire technical critique of the law. In making that first proposition, what I was saying is this, that if you land up just doing only context, or you just kind of only teach black letter, both of those are problematic. So for us, the challenge is, how do we do the melding? And as Hartini was speaking, I was reminded of, a few years back, I was almost consumed by, there's this book by Edmund Kahn, where he talks in terms of the sense of injustice. And in his wanting to settle up what the legal curriculum should be, he talks in terms of developing in students what he calls a sense of injustice. That is, you should be able to see when injustice happens, that this is unjust. And then what you need to be then devising and working out is how you're going to get people to move from this space or place of injustice to justice. And in doing that, in traversing that area, you need to have good, hard legal, Harini's he's been using the term skills. I wouldn't say necessarily skills, but at least, all of those techniques that you require to know, how do you read a legal text? How do you, if you want to be questioning a specific situation, how do you argue for it that the way of reading the text or what you read in the text is addressing the injustice before you? And Kahn also speaks in terms of just not informing the head, but also informing the heart. To say that because if you are not going to develop people's emotional intelligence, that sense is not going to come. It's not about the reasoning of justice. It's talking in terms of developing a sense of injustice. And I felt that that was the other component one was trying to stress on. So when we speak in terms of like, we've had journalists and, what should I say, people who dramatists and, people who work on the stage, entire performance people coming in and talking to students, because you felt sometimes a well-performed play on critical issues of justice and injustice takes the student way further than however many Supreme Court judgments you may teach them. So now the question is then, okay, this is the objective you wish to achieve. In reaching that objective, what are the places that you need to traverse? So when we speak in terms of like, okay, what is the kind of theorizing which is coming in from the global north, or the fact that we are living in this globalized, liberalized world, whatever, I somewhere do feel that at no point of time should we be in the whole realm of scholarship, and especially legal scholarship, which is divorced from asking questions of whether this is fair or unfair. Is it just or is unjust? Is the entire, if I'm studying international law, I mean, why do we all go for the third world approach to international law? Because we are being told that if you are going to study, and if you're only going to, that's where in a little bit I wanted to make it clear that, Hartini, when you were saying, I did want this to be understood, that when we teach them also what is in the law, we need to be saying that this entire realm of international law, which is being handed out to you, has been constructed by a certain power system. And if you are not going to be cognizant of the fact that there is a power system behind it, which causes for these international norms to come, then you're going to uncritically sort of engage with it. So to develop that critical, let's say that critical sense in our own students, we have to constantly do these both. Sometimes what happens is, because the whole technical realm of law is also so huge and be so overwhelming, and to be sort of saying, oh, you need to be like masters in it, we forget all the things which have happened behind that, what has caused for this to become the norm. And I think for me, the entry point for interdisciplinarity primarily comes from there. So whatever may be the context, whether the context is you're looking at the injustice which is happening because of the manner in which global forces are operating, or the injustice which is happening because of the way in which, say, caste or color or religion is happening, you need to be constantly telling your students, how do you get the two to converge? You can't do one without the other. If you have that sense of injustice, if you really have developed it well for them, then you also need them sort of impart to them the skills by which they can get people out of that injustice and to a fairer and a more just sort of place. That's how I would address the question with which you were starting this particular segment of the discussion. But I also wanted us, I think in some way or the other, at least I can definitely speak for, as somebody who's at all points of time come to law by looking at what other disciplines or other sectors or other people have to say about the law. At the same time, one is enough of a proponent of the whole autopoietic way of looking at things, that if the law people themselves don't see that there is something not right, all the critique can come from every other discipline, but change will not happen in the law. For that to happen, it's important that critical understanding has to be cultivated within the discipline of law, within the institutions of law. So I think for us, this business of looking at law and other things has to be a two-way traffic on a constant basis. The other thing also is, as law people, we are very comfortable in pronouncing on the whole world, but we make it very, very difficult for people from other disciplines to pronounce on the law. So if critique has to happen of the law, it necessarily has to come in the first instance from law people. That's how I see it. Because I've always found, you and I want to speak about whether it's architecture, whether it's engineering, whether it's anything, as a law person or psychology or philosophy, you have an opinion, you can say it. But if anyone from any of the other disciplines wants to have a critical understanding of law, you will turn around and tell them, no, but you don't understand legal language. This is not how the law operates. And you constantly terrorize everybody else. So making it more difficult to critique what happens within the, whether it's the legal institutions or the creation of legal norms. And I would sort of say that how we look at the global north too, if critique has to be coming in, we have to firstly comprehend what are the power dimensions which cause that to come.
Thank you. Professor Biggs, you want to take it?
That's thank you, Professor Dhanda. That was very, very interesting. But to go back to the question about the global north and the influences in with regard to South Africa, and with regard to legal education, as I've mentioned, the national review of the LLB in 2016, 2017, at the same time was taking quite important, there were major activities and taking place in the country at the same time, with regard to the whole decolonization, the call for decolonization of legal education that was really got going, in South Africa. It was earlier, much earlier, but, there were, lots of emphasis in 2015 with, the lots of different calls and, for the fall of various roads must fall and those kind of things that happened, as well as then, the request and the deep discussions and regarding the decolonization of not only the legal education and the law curricula, but the entire higher education, system. So those discussions have been taking place throughout the institutions in South Africa, and has been, at the forefront of many a conference and research. And then at the same time as that, while that was happening, we then started with the fees must fall situation, and in South Africa as well. So we constantly needing to reflect and consider whether our legal education is relevant for the society within which we live in South Africa, and to ensure that it is that the way the legal education and the law degrees and the graduates that we have will be able to provide that service to community, to identify the injustices of everybody within, and to ensure that the values of our constitution are forefront of the mind of the legal scholar or the law graduate that we're producing. The values, those intricate values, those need to be it's part of they need to be installed in the students, and of course with our university namesake being Nelson Mandela, we also it's part of our teachings and our practices and behaviors is to live the values of Nelson Mandela as well. So we hold forefront the Constitution and the values of the Constitution, and at the same time it's about being a Mandela. So in order to do that, as you say, Professor Dhanda, that the graduates, when they need to know what those injustices are in order to ensure that those injustices are eradicated. And as and that is part of our role as the teachers, to constantly evaluate and critique and review and reflect upon our teachings against the past and the histories, but historical perspective, but also the context in which we the current situation and where we are going, to ensure that yes, we are a university at the tip of the African continent, the bottom tip of the African continent, the global south, taking all of those aspects into consideration, and And if we go right back to the very first question is, is it important for interdisciplinarity within legal education? Yes, we've all said that students need to know what is going on in other disciplines in order for them to properly be of service to the communities within which they will be practicing as legal practitioners. Thanks.
Thank you. Professor Saripan, you want to go next?
Yeah, thank you, Professor Anuj. I think I would like to add by sharing, our practice or our initiatives at the university here. One of the focuses of UITM is to make sure that our graduates are able to practice not just locally in Malaysia, but also abroad. So we have put efforts in bringing in experts around the world, either as our consultants and from time to time we receive feedbacks in order to make sure our curriculum is current, and more importantly, our curriculum is sufficient or even more than sufficient to prepare our graduates, to practice globally. So yes, we do locate ourselves within the global practice. And speaking about to what extent this interdisciplinarity is taken into account in locating ourselves, I think, that is again goes back to what is the purpose of having this interdisciplinarity. Professor Biggs, asked a very important question to you, Prof. Anuj, as to what is this? And I think from our discussion, it can be understood from two perspectives. One, either we are talking about specific programs marrying two fields, law and other fields, or another spectrum that I believe, that has become our direction also, is to what extent these tools and techniques are being infused in order to enhance the quality of law graduates. And that is where UITM, that is where, I am going into our discussion. And I think I would also like to add the fact that another important emphasis of UITM is to be able to share our expertise and our legal knowledge with community. And this is where social science research technique is seen to be one of the tools that is used to make sure that our legal knowledge is able to reach out to the community. So we have been discussing here in Malaysia about how translational research will be able to be used as a tool for law teachers or even law students to reach out to community and to really translate our legal knowledge into practice and make sure that this will be able to be shared with community. So this is also one of the focuses of the higher education ministries in Malaysia, that is to make sure that that is to make sure how university will be able to touch the community and share knowledge with the community. And speaking from the law school, I think, the Malaysian law schools in general, when we have discussions amongst the law deans in Malaysia, we agree that some of the techniques in other fields may be used in order to achieve these objectives. For certain reasons. For example, community, there's a challenge for community to understand legal jargons, and all that. So translational research technique is also used in order to make sure that whatever legal contents can be shared with the community. And I think another point that I would like to also share here is how we at UiTM equip our students with the other skills, because we at the faculty, we have 162 hours, and these hours are mainly, for the legal body traditional law subjects. So we have to think of the ways of incorporating, other skills and tools in order for our students to shine, especially when they graduate. So what we do here is to incorporate law experts and law professionals with us in order to become the mentors for our students throughout the years of their studies in UiTM. So eventually they get mentoring from these law professionals, and they are basically judges, experienced lawyers, and these experts or these industry players will whisper, to them and tell them what are the things, other than law that needs to be made aware, to these students before their graduation. So I think that's from me. Thank you.
Thank you, Professor Saripan. And I think we are out of time now, so we will conclude now. And I just want to thank you all for sharing the kind of interesting pedagogical experiments going on in your parts of the world and reflecting on them critically. I think it was an interesting conversation for all of us. Thank you all. Thank you, Professor Saripan. Thank you, Professor Dhanda, and thank you, Professor Biggs.